Good afternoon and welcome to today's webinar on the new regulatory landscape considerations for UK traders. So any of you that don't know who I am after all of these months, then I'm Andrea Collins. The company is the Export Department, and we're delivering the EU Exit Support Programme on behalf of the East Midlands Growth Hub Cluster. So this is, I've lost count of which webinar this is, but there's a series of 14 of them and we're approaching the end. This might be the 12th actually. So today, as the title would suggest, we're going to be talking about the regulatory landscape and what that looks like after our departure from the EU. Okay, so just by means of a very brief agenda, apologies, just by means of very brief agenda, we're going to be talking about introducing the EU Exit Support Programme to those of you who aren't familiar with it, so what it entails. We're also going to be talking about where we are now, post-transition period end and what that means. We'll touch a little bit on the Northern Ireland Protocol because that does impact how we view the Northern Ireland market and the Great Britain market as well, because that Northern Ireland Protocol has kind of changed. There are regulatory considerations for placing goods on the Northern Ireland market and the GB market. We'll talk about the changes or not so many changes to employment regulation. We'll look at it through the lens of trading in goods. We'll look at what regulatory changes mean for the movement of people. We'll look at consumer protection, dispute resolution, data protection. We'll touch a little bit on intellectual property and a little bit on taxes, but we've covered taxes in several different webinars before. And we'll cover off the CE mark as well and the e-commerce directive, because that ties in very nicely to a webinar that we're doing. I think it might be the next one in 2 weeks' time that talks about e-commerce and the implications for VAT in the EU and the changes that are coming up there. And we'll also talk about the Audiovisual Media Services Directive. That is something that's hitting the audiovisual media sector. Just really want to give you a kind of, without knowing who's going to attend these webinars, it's impossible to cover everybody's sector, but I think just to give you a taste of some of the changes that are taking effect that might actually make you think about your sector and what to go and take a look at, make sure that your understanding of those regulatory changes and how you remain compliant moving forward. And then we're just going to look at a couple of sectors, for example. So I've pulled together a slide on the food and drink sector, the technology and innovation sector, and life sciences as well. Okay, so just by means of introducing the EU Exit Support Programme, so as I say, it's a series of topical webinars. So the one coming up in 2 weeks' time is about the complexities of B2C sales into the EU, and a lot of that concerns VAT and the new one-stop shop regime that's coming into force in July, hopefully this year. And then 2 weeks after that, it's all around service companies. So much of the preparation for Brexit surrounded trade in goods, and service companies were kind of left high and dry in many respects. So it's important, we're a services-based economy in the UK, some 80% of our GDP is services, so it's important that those very valuable companies know, you know, what the new landscape looks like for them and how they need to best prepare. And so they're the webinar side of things, but then we've also got the dedicated one-to-one support, whereby we have one-to-one sessions with businesses that are impacted who believe they're particularly vulnerable in light of us leaving the EU, and we pull together targeted action plans, and then we do tailored follow-up support following on from that. So very much lifting the bonnet on your organisation and delivering dedicated support according to what you need, whereas the webinars are perhaps a little bit more generic. This is the link to Eventbrite, where you can sign up to the webinars as you've done today, and also to the dedicated one-to-one support. So where are we now? So obviously we're out of the single market, we're out of the EU Customs Union. We no longer are party to those 70+ free trade agreements negotiated on our behalf by the EU, and also, you know, several other that were in the process of being negotiated or ratified when we left. We've left the EU VAT scheme, which doesn't have such a big implication for services, but is affecting goods, particularly on the consumer sales side of things, which again, we're going to talk about in a couple of weeks' time. We now have third country rules apply. So outside of the single market, we're no longer local companies in relation to our EU counterparts. We're now third countries. We're a third country in the eyes of the EU, and they're a third country in our eyes as well. So our commercial terms and everything wrapped up in that, our whole agreements need to be a lot more robust and a lot more structured moving forward. We've now got customs formalities and border controls. Not so much on import into the UK, because the UK government adopted a phased approach to import controls, which they've subsequently extended actually towards the end of this year. Essentially, we're not quite ready to impose the same kind of controls that the EU has been imposing on us since the 1st of January. So as I said in several webinars now, a phased approach to imports into the UK, but for our exporters, they've had to get their head around these kind of new EU border controls from the 1st of January, and it's caused a little bit of pain. UK courts replace the European Court of Justice. I've put an asterisk there because the European Court of Justice will still oversee some UK companies when they're taking part in those flagship programs like Horizon and so on. The European Court of Justice still reigns over companies when they're participating in those programs. We've now got the UK-EU Trade and Cooperation Agreement in force, which covers trade and services. It was launched obviously on Christmas Eve. It was promoted as being no duties, zero duties, zero quota. I think there was a misconception that would mean that life remained the same, that it was free movement of goods. It's very, very different. It's rules of origin that dictate preferential trade in this case. And we've now got the UK government is negotiating its own free trade agreements and continuity agreements across the globe. So we've got probably the most notable ones that they've been proud to announce are the UK-Japan agreement, which was essentially a carbon copy of the EU-Japan agreement. Obviously Singapore. I did catch something in the headlines today about Indonesia as well, but to be honest, we import goods from Indonesia under the generalised system of preference anyway, so we don't pay duty on goods coming in from Indonesia. But the government's got a fair way to make up the kind of preferential trading landscape that we had as party to the EU, and it's been a bumpy start on both sides of the channel. Our EU counterparts are feeling the pain just as we are. So the Northern Ireland Protocol, I wanted to touch on this because Northern Ireland has kind of been suspended in a hybrid state somewhere between the UK and the EU. So it remains in the UK customs territory, but it remains in the EU single market for goods, and it remains closely aligned from a regulatory standpoint and from a VAT standpoint. So the Northern Ireland Protocol was negotiated as part of the withdrawal agreement back in 2019 and actually unlocked the negotiations, if you like, so that was a major sticking point. It effectively places this border down the Irish Sea. So it means there are implications for UK businesses UK businesses, depending on where the goods are moving from and to. So they're treated slightly different. So for trade coming from Northern Ireland into GB, there's no additional processes or paperwork or restrictions. But for trade going into Northern Ireland from GB, there could be tariffs if the goods are ultimately entering Ireland, or if they're at clear or substantial risk of doing so, rather than staying in Northern Ireland and therefore within the UK customs territory. There are additional processes for goods arriving in Northern Ireland from GB, where those goods have special requirements placed on them. So goods like products of animal origin that warrant specific checks and controls, and they're going to have to be implemented at border control posts within Northern Ireland ports. So a lot of changes, and it seems very strange for us as GB companies to be treating, to have to be dealing with another country that's in our customs union in this manner. So important points, the border operating model that was announced in July last year and subsequently updated several times, the last version is December, that doesn't include arrangements for the flow of GB and Northern Ireland goods under the Northern Ireland Protocol. So if anybody on the call today is a GB company that is shipping to Northern Ireland, then I would strongly recommend that you sign up to the Trader Support Service, or TSS. You may need an XI EORI number if you're going to be making any kind of declaration in Northern Ireland. It's important to say that when we're moving goods from GB to Northern Ireland, the declaration is made in Northern Ireland, so it very much depends on the Incoterms, if you like, or the shipping terms that you've agreed with your Northern Ireland customer as to whether you make the declaration in Northern Ireland or they do. But TSS is a free service, it's free to use, it's funded by the UK government. If you sign up, there are a ton of free training videos to explain how the whole process works and what the obligations are on you as a GB trader, or indeed you may be attending from Northern Ireland today, you could be a Northern Ireland customer. There is within the protocol this notion of goods at risk. So a second ago I mentioned how tariffs could apply at the Northern Ireland port with GB if the goods are at risk of entering Ireland, which in actual fact would be entering the EU. So where a trader can't guarantee that the goods arriving from GB will remain in Northern Ireland, so stay within our customs territory, then the EU applicable tariff applies, and it will apply if it's over zero. And the theory behind this is, if you imagine when we send goods within our customs territory, we don't charge any tariff, we don't charge any duty because we're within the same customs territory. So goods going into Northern Ireland would have zero duty, but if they are at risk of entering Ireland, then that EU duty would be applied at the Northern Ireland port on those goods. Now, if the trader wants to make a declaration and in actual fact the goods are staying within Northern Ireland and therefore waive that duty, then they can make a declaration via the UK trader scheme to say that those goods aren't entering the EU and therefore no tariff applies. So lots of things to think about there. Freight forwarders and fast parcel operators will be quite good sources of information in terms of making these declarations and what your obligations are. I think for the purpose of today, I wanted to kind of get across how we're talking about technically 3 separate territories now. We're talking about EU, Northern Ireland, and GB for the purposes of regulation, because we have that regulatory gap now between GB and Northern Ireland, despite the fact that we're in the same customs territory. Now, I don't know whether many of you saw on the news a few weeks back, but the UK has unilaterally extended the grace period for the need for declarations for B2B goods entering Northern Ireland. So they were meant to come into force on the 1st of April. The government has unilaterally extended that grace period to the 1st of October. Now, the EU isn't very happy about it, as you can imagine, but what that means for Northern Ireland customers or GB traders, depending on who's making the declaration, is that goods can still flow into Northern Ireland without those declarations up until the 1st of October. So it's just extending that grace period while we become accustomed to these new changes. Moving on to employment. So you may remember during the negotiation that was getting very down to the wire back in November and December last year, there was a lot of tension around creating a deal that ensured a level playing field for the EU, but a deal that also maximised what the UK wanted in terms of sovereignty. And we heard reference to this level playing field, which is really a trade policy term that describes a set of common rules and standards that prevent businesses in one country or trading bloc from gaining a competitive advantage over those operating in other countries. And this is really a key element of the EU single market that allows for that free movement of people, goods, services, capital, and maximises that open and fair competition. So the UK government really wanted to perhaps deviate a lot more from where the EU was on a whole set of regulation. But where employment is concerned, the Trade and Cooperation Agreement sets out that both parties now each have the right to set their own policies and priorities for labour and social standards. So I've listed what these are here. So we've got fundamental rights at work, occupational health and safety standards, fair working conditions and employment standards, information and consultation rights at company level, and restructuring of undertaking. So we have the right to set our own policies and priorities in respect to those standards. But there is a non-regression clause within the Trade and Cooperation Agreement where both parties have committed not to weaken or reduce the level of labour and social protections that are in existence or were in existence before the transition period end in a way that could affect trade or investment. So in a way that could, make one party more competitive than the other. Both parties have also committed to continuously strive to increase their respective labour and social levels of protection. And this whole level playing field conversation, and we heard reference to rebalancing measures, and that's really both parties understanding that if they deviate, if there are significant divergences in protections around employment that arise in the future, and those divergences have a material impact on trade or investment, then there will be what we call rebalancing measures, and that's effectively the imposition of tariffs and the suspension of parts of the Trade and Cooperation Agreement. So during the negotiation, it very much sounded like it's the EU that was imposing this on the UK, but in actual fact, both parties have signed up to it. So if the EU was to deviate, then the EU could impose punitive measures on, the UK could impose punitive measures on the EU, but it's really a way of trying to protect both parties. And because we've got that close proximity, geographic proximity, and our supply chains are so tightly integrated, that's why it's really essential that we have that fair, open and balanced playing field. I suppose thinking about examples of what could represent an unfair advantage would be, for example, if the UK lowered its employment standards, or it lowered the national minimum wage to create a cheaper labour market that would make it more attractive and competitive over and above the EU. So they're things that could incite those punitive measures that I mentioned. So when we're talking about enforcing labour and social standards in the 5 areas that I've listed, then the agreement states that parties have to put in place a number of things which I've mentioned here. So an effective system of labour inspections and so on and so forth. In terms of that close regulatory alignment and how that looks moving forward, I think regulatory divergence should be on all of our risk registers, because we're no longer party to the same block, we're no longer party to the single market, and I think over time there will be divergence. But the Withdrawal Act, signed in 2019, created the concept of retained EU law, which essentially means that EU-derived employment law, so that was in place before the 31st of December, continues to apply. So that means, we continue to abide by the EU Working Time Directive, the General Data Protection Regulation, TUPE for transfer of undertakings, protection of employment. And there are actually something like 150,000 other pieces of EU-derived legislation that the UK will continue to abide by. And in actual fact, the UK courts still have to follow any case law that was established by the European Court of Justice before the 31st of December. So there's close regulatory alignment at the moment. Now, in terms of moving forward and avoiding these rebalancing measures that I talked about, the UK is going to have to implement versions of certain EU directives within the next 2 years to prevent those rebalancing measures being initiated. So we're going to have our own version of the Whistleblowing Directive, Transparent and Predictable Working Conditions Directive, and the Work-Life Balance for Parents and Carers Directive. Now, I think for UK employers, I think this is just a very positive thing, because the EU has very high standards of employee protection. The UK has been at the forefront of some of this legislation. So I actually think it's a very positive thing that we stay closely aligned in this respect. That's just my opinion, obviously. There may be some areas where the UK will diverge. The government has already announced, areas that it wants to kind of simplify or restructure. So holiday pay calculation, for example, the UK government sees that as being far too complex. Compensation for discrimination cases, they want to introduce a cap on that, because currently there's no cap in place. And then UK TUPE, they want to make that less restrictive and more employer friendly. So there are a number of areas where the UK government wants to diverge, but they're not seen to be areas that will upset the EU in any way, or create a case for implementing those rebalancing measures. Just touching on trading goods for a little bit, so and what the Trading Cooperation Agreement says. So obviously we've got the UK Customs Territory, we've got our own trade agreements now, we've got our own version of the UK Generalised System of Preference, GSP, so we've left the EU GSP. We've got we've now got tariffs depending on where the flow of goods are. So you can have EU goods coming into the UK that don't face any tariffs, providing they're of EU origin. UK origin goods going into the EU will be under preferential trade. But should those goods go back, so say for example the UK exports UK origin goods into the EU, they come back unaffected, unprocessed, and unless they're returned goods, then when they come back into the UK, then they will face that that third country duty. So it's very far removed from free circulation of goods, and it's the rules of origin that dictate that preference. So now, as manufacturers, we have to be looking at our bills of material to determine whether our goods are actually of UK origin. So is there sufficient UK raw material and UK processing to confer UK origin? Now, remembering that the Trading Cooperation Agreement includes that bilateral accumulation, so we can still count that EU raw material and processing as UK origin, but only for the purposes of EU-UK trade. In terms of trade remedy measures, so with regard to like anti-dumping, anti-subsidy and safeguard measures, there's no distinction on the origin of goods in the Trading Cooperation Agreement, so international rules apply for UK and EU origin goods as they would do for third country goods. So we can, for example, if the EU decided to flood the UK market, which it wouldn't, but if it decided to flood the UK market with cheaper goods, we could impose anti-dumping measures on those goods even though they're coming from the EU. So those kind of trade remedy measures, those trade remedy measures can still be applied. We've actually replicated EU measures within our tariff to protect the UK industry from dumping practices. So we haven't really deviated, but it means that we can impose them on EU companies, EU countries now, as well as the rest of the world. In terms of licensing requirements, so WTO rules, World Trade Organization rules that both the EU and the UK have signed up to, they dictate that the case for licenses should be neutral in application, and they say that they should be administered in a fair, equitable, non-discriminatory and transparent manner. Now, the EU and the UK are operating separate import and export license procedures, so a license under EU law won't be any longer valid for importation into the UK and vice versa. But there is an exception in the case of dual use items. So both the EU and the UK have removed the need for exporters to apply for individual licenses. Now, Northern Ireland, fly in the ointment, that operates slightly differently. So controlled items that currently move license free between the EU and Northern Ireland, that is as good as is because it's free circulation of goods they're still in a single market. However, when exporting from Northern Ireland to a non-EU country, so that could be to GB, for example, then an EU member state issued license is no longer valid and a UK license would be needed. So anybody dealing in controlled goods, then just important to take away from today that there are considerations where Northern Ireland is concerned. Now, in terms of people, and obviously our departure from the single market has removed that wonderful freedom of movement for people. So we now are kind of abiding by WTO rules in terms of the movement of people. So depending on the purpose of entry and temporary stay, the Trade and Cooperation Agreement lists 5 routes for UK nationals to choose from, and I've listed them here. So you've got a business visitor for establishment purposes, so that's an individual that's employed as a senior executive or something that's responsible for setting up a legal enterprise in the host country on behalf of the overseas company. So they've got the notion of that kind of individual. They've also got contractual service supply. So that's an individual that's employed by a UK entity that does not have an EU presence, for example, and they must have worked for that UK company in the same type of services for at least 12 months. There are, depending on the member state that they're going to go into, there will be different entry level requirements. So some may dictate that the individual has the necessary qualifications, so certain number of years professional experience or degree educated and so on. They may need an economic needs test, which is commonly known as a labour market test, and that could be required for some EU countries depending on the sector that the individual is going into. So, for example, Hungary requires an economic needs test for activities falling under management consultancy services, but some other member states won't do. And of course, we've got this issue now as well, where we've got no mutual recognition of qualifications that could cause an additional issue and might mean that a license is required to engage in a highly regulated activity, for example. Then we've got the notion of independent professionals. So these are the self-employed people in the UK that haven't established a presence in the EU. Again, they're independent professionals. They may need an economics needs test. For example, the Czech Republic requires a needs test for activities falling within computer and related services, but other sectors, other member states might not. And those independent professionals might need local professional qualifications. So we've got this situation, at least with the mutual recognition of qualifications, so we might have a bit of a patchwork appear in terms of some qualifications recognised in some member states and not in others, because part of the negotiation, the EU wanted recognition of qualifications for UK professionals to be at the member state level, and the UK government wanted it to be at the EU level, and the UK government lost. So essentially, federations and associations here in the UK are going to have to interact with their counterparts in each member state to work on mutual recognition of qualifications. So that's where that patchwork may appear. Then we've got the notion of short-term business visitors. So this is like visa travel for short-term visits in accordance with each of the member states' domestic law. So the TCA, the Trade and Cooperation Agreement, has a list of permissible activities for short-term visits, so say for meetings, research, training and so on. But you must again consult the individual member state of where you're going. So for example, Austria will generally require a work permit for after-sales service, and that might also include an economic needs test. So you must, and if you look at the Trade and Cooperation Agreement, there are several tables where it shows quite clearly, depending on the member state that you're going into and the nature of work and the duration of the stay, what those kind of entry level requirements are. Now, for EU nationals entering the UK, there's a little bit of preferential treatment in so much as they've got an app to enrol, so they don't need to attend an appointment at an overseas visa application centre. They can receive digital immigration status. They can enter the UK via the skilled worker route. So now there's no annual cap on the number of work visas. Resident labour market tests are eliminated, and the skills threshold has been lowered from degree level to A level, so from RQF6 to RQF3. And trade attributes will be introduced to compensate for low salary with PhD in a relevant field or a shortage occupation job. So there's been a number of different changes in terms of what UK companies need to do to hire EU nationals. But there is this, now that we've moved to a points-based immigration system, employers are going to have to be sponsors to hire these individuals, and they may be reluctant to pay an additional, what could turn out to be £3,000, £5,000 to hire a UK national, regardless of the relaxation of the requirements to obtain a work visa. EU nationals can also come in via an intra-company transfer route. So that allows international assignees to switch their immigration status to the skilled worker route, which leads obviously to settlement. And an intra-company transfer time can be counted towards the 5-year residence requirement for settlements. There's been changes there. So if you're a UK employer and you recognise the valuable talent that EU nationals can bring to your organisation, then it's important to understand that the terms of employing them has changed. And there are a number of different considerations around certificates of sponsorship as well. So we've now got the notion of undefined, which is broadly the same as the previous system for unrestricted, and defined, which is broadly similar to the former restricted certificate of sponsorship. But just important to signpost you to the fact that things have changed should you need to obtain further information there. In terms of consumer protection, so as we know, consumer protection, high standards across the EU, and it essentially serves to level the playing field between businesses and consumers when they contract with each other. So it includes, key provisions like the fairness test. So that says that contractual terms and notices can't create an unfair imbalance in favour of the business. The transparency test, so contractual terms and notices have to be plain and in intelligible language, and the right of withdrawal, so the right of a consumer to cancel a contract within 14 days. And then there's implied contractual warranties and remedies. So there's a set of kind of implied contracts within consumer protection law. And it's really formed from many different legislative sources, most derived from EU regulation, for which the UK again has been at the forefront of some of it, like the Consumer Contracts Regulation and the Consumer Rights Act. Now, consumer protection law hasn't really significantly changed from the 31st of December. One of the major differences, I suppose, is the online dispute resolution. So the Commission operates a dispute resolution platform known as the ODR, the Online Dispute Resolution Platform, and it resolves disputes arising from those cross-border B2C transactions because it has that approved dispute resolution body. But now UK consumers can't access that platform to make a new complaint, and UK businesses can't access the ODR platform either. So we've lost that. So I suppose it becomes a little bit more difficult to get resolution if you're a consumer and you've bought goods from the EU. There is cooperation between national enforcement authorities. So the Consumer Protection Cooperation Regulation that was in place has been revoked. So that regulation sought to kind of make it easier for the EU enforcement authorities to cooperate when there was a breach of consumer protection, and it enabled the Commission to coordinate actions between national enforcement authorities. That has now been revoked, so that ties into what I was saying before about it becomes more difficult for consumers to resolve any issues that they have. What we call the P2B regulations, the platform to business regulation, that imposes obligations on platform and search engine operators where those platforms or search engines allow businesses to reach consumers in the EU. Now that regulation will continue to apply to platform and search engine operators based in the UK where those platforms and search engines are used by EU-based businesses and reach EU customers or consumers. But the UK has implemented additional legislation to create a kind of dual regime, and we're seeing that a lot with regulation. We're now operating dual regulatory regimes. But this one, the UK P2B regulation, obviously the scope applies to just UK-based businesses selling to UK-based consumers, but we've kind of replicated that EU regulation. And then, you know, another thing to mention is the choice of law. So I suppose the prevalence of online trade has meant that many businesses transact on a cross-border basis, and they need to understand what laws are going to apply to their B2C online contracts. Now, currently, businesses can elect the governing law of their B2C contracts, but they usually seek local law advice when directing their activities to a particular country to ensure that the contractual terms are enforceable. And really important to mention that the UK has enacted legislation that contains equivalent rules, meaning that the principle of electing the governing law but being subject to mandatory local law in the countries in which services are directed will continue in the UK as well as in the EU. So again, we've kind of replicated what was already in place. In terms of future divergence, so the UK is actually not obliged to implement EU directives that hadn't reached their implementation date before the end of 2020, or that hadn't that weren't in EU retained law before the end of 2020. But there are significant upcoming changes to EU consumer protection law that won't therefore automatically become UK law. And you could say, does that put UK consumers at a disadvantage? Because again, consumer law in the EU is of a very high standard. So those changes in EU consumer protection are the Digital Content and Digital Services Directive, the Sale of Goods Directive, and the Enforcement and Modernisation Directive. So there's a few changes happening on the EU front, but the UK is at no liberty to copy those. Dispute resolution. So I'm just very conscious of time here, but the UK has now acceded to the Hague Convention, and the Hague Convention provides a reciprocal recognition of enforcement system for parties that choose exclusive jurisdiction of the UK courts. So the UK government says that it applies to contracts entered into after the 1st of October, but the EU says that it only applies to contracts entered into from the 1st of January when the UK acceded in its own right. So that could cause problems moving forward. There are implications for companies who have contracts with exclusive jurisdiction clauses in favour of either a UK or an EU court. Then they may find that they need some legal advice to determine whether they're enforceable under the Hague Convention or whether the common law or national rules will apply. In terms of governing law, so law governing parties, contractual and non-contractual obligations have been incorporated into UK domestic law. So there's certainty and continuity between the EU and UK legal frameworks because these rules are not reliant on reciprocity. What else do I really want to mention? Arbitration. So EU rules on jurisdiction, governing law and service don't extend to arbitration. So Brexit's actually had very little immediate impact on this area of dispute resolution. So I suppose considerations for UK traders may sound obvious, but dispute resolution and governing law clauses should be drafted to make clear which courts are to have jurisdiction in the event of a dispute and which law is to govern the contract. Try where possible to select an exclusive jurisdiction clause in favour of the courts of England and Wales, but always obtain legal advice to make sure that that's the best option for both you and your EU counterpart. And then as arbitration is effectively unaffected by Brexit, then, is it worth considering arbitration? Would that provide greater certainty as a method of dispute resolution? So lots of things to think about in terms of your commercial contracts there. Data protection, I'm delighted to say I could summarise all of this by saying that the European Commission's draft data adequacy decision was announced, I think, back end of February now. So essentially the EU has in draft form said that the UK meets its data adequacy level. So any of you that are responsible for the obtaining and processing of EU personal data would have been feeling a little bit hot under the collar leading up to the end of December as to whether or not you could continue processing and storing and all sorts with that data. We're in kind of like a bridging mechanism at the minute, whereby in the Trading Cooperation Agreement it says that we can continue to process EU data until the end of April, with an option to extend to the end of June, pending further negotiation between the UK and the EU on this adequacy subject. Delighted to say that, you know, the EU has recognised that we meet that adequacy level, so all they need to do is to get that technically approved before this bridging mechanism expires at the end of June. So hopefully that's in place to do that. So effectively data protection will remain unimpacted by our leaving the EU. Intellectual property, just really a couple of things here. So exhaustion of rights. The UK has obtained the ability to set its own permanent regime for exhaustion of rights. So UK IPO will be consulted on at some point this year. When we talk about exhaustion of rights, what basically means IP rights cannot be used to stop the further distribution or resale of goods. Trademarks, obviously, you know, when we were helping businesses prepare for the end of the transition, we were asking them, you know, to take a look, to audit their IP and to understand whether they had any trademarks that were registered in the EU, and those that were registered, you know, just in the UK. In terms of the Trade and Cooperation Agreement, both parties have committed to retaining minimum standards on trademarks. So they're all enshrined in EU and UK law. So, you know, the types of signs that can constitute a trademark and the grounds for revocation and so on are all agreed, and both parties have signed up to that. Those European trademarks now have comparable UK trademarks, but you know, now companies are having to maintain European trademarks and file separate EU and UK ones for future IP. So it's a bit of a pain there, whereas we would have been just filing one EU trademark, we're now filing a UK one and an EU one, depending on where we're selling our services and goods. The other thing I wanted to mention was .eu domains have to be transferred, I think, before the end of June. So if you've got a .eu domain, they need to be transferred to an EU legal entity, otherwise they will be permanently switched off and won't be able to use for any web hosting or email or so on. I'll mention geographical indications just because they come into play in the food and drink slide in a little bit as well. So there was unfortunately no agreement on the protection and enforcement of geographical indications, those GIs. They're those signs on products that have a specific geographical origin and possess kind of qualities or a reputation that are due to that origin. So now the UK has its own GI system. And the EU has its own GI system, and we will see divergence over that moving forward, because the EU's recently consulted on extending the GI system to non-agricultural products, whereas the UK has no desire to do that. What else? I think we'll come on to some of this as we move forward, actually, on some of the other slides. I'll move on. In terms of taxes, so EU VAT rules no longer apply in GB, in Great Britain. So obviously our goods that we export are zero rated when they go to both consumers and trade customers, and that VAT becomes import VAT in the country of destination. It's also meant that we've lost supply chain triangulation simplification, which is a bit of a mouthful there, but was a fantastic mechanism for you know, the movement of goods. Say, for example, a UK company wants to ship its Spanish customer directly from its French supplier, then the VAT rules were very simplified there, whereas now they are an absolute nightmare. But that's a conversation for another day. In terms of services, place of supply rules haven't really changed. So B2B VAT is still where the customer resides, so they account for the VAT locally in their own market via the reverse charge. But for UK companies, there's no more completion of EC sales lists. Services supplied to Northern Ireland are subject to UK VAT, and on a B2C side of things, obviously the supplier resides, the VAT is where the supplier resides, except in the case of digital sales and a couple of other exclusions there. We've now got postponed VAT accounting as a mechanism for dealing with import VAT on goods that come into the UK, which is obviously an alternative to using a duty deferment account, which some companies might not have or might not be, you know, might not easily be able to obtain. As I said before, Duties, VAT is zero rated on all exports, and UK traders are required to maintain that proof of export for 6 years, and that proof of export will be different depending on whether you're using a freight forwarder or whether you're using a fast parcel operator to ship your goods. In terms of fiscal representation, the TCA, the Trade Cooperation Agreement includes a protocol on VAT and mutual assistance, which is fantastic, because we were thinking before the 24th of December that we were going to need fiscal representation in 19 of the 27 member states, and that's actually been that's not a requirement due to this protocol on VAT and mutual assistance, which is great. Any companies using the UK MOS or mini one-stop shop can no longer use that to report and account for EU VAT on B2C digital services to customers. So where UK suppliers want to continue supplying digital services to EU consumers, they have to switch from the UK VAT MOS to non-union scheme in a member state. And that's for digital services. Now, EU OSS, or the one-stop shop, you may have heard reference to this. Basically, the EU is revamping its VAT system. It should have happened to coincide with the end of the transition period, but it was delayed to July. But that is kind of an extension of the mini one-stop shop that's been in place for digital services to cover other B2C suppliers of services that are taxable in the EU. And that's going to be really, at least from the import OSS side of things, for UK e-commerce retailers, it's going to be quite transformational. So again, we'll cover that in a couple of weeks' time. There's also been changes to how we can get VAT back, essentially. So all VAT refund claims, you know, where EU VAT's incurred on goods and services now need to be made using the 13th VAT directive process. So UK businesses might be required to provide something like a certificate of trading or certificate of status to get it in order to get that refund. So there's changes there in terms of getting a refund on VAT. The CE mark, very briefly, because I'm sure a number of you know the changes or will have heard about them. Essentially, any products that carry the CE mark will now need to carry the UK CA mark. So we have kind of divorced in terms of that conformity assessment mark. And as any of you know, if your products are impacted by it, then it's that mark that demonstrates that your product meets those safety, health and environmental protection requirements. The UK CA mark, so it stands for UK Conformity Assessed, it's a new UK product marking that's going to be used for products placed exclusively on the Great Britain market, so England, Wales and Scotland. And it'll cover most goods that previously required the CE marking. But it's important to remember, because of the regulatory divorce between GB and Northern Ireland, the UK CA mark will not be valid in Northern Ireland, nor will it be valid in the EU. So a lot of products are going to have to be dual mark now, with the CE mark and the UK CA mark, where they're products that are placed on both the GB, Northern Ireland and EU marketplace. Also important to remember that the EU and the UK no longer recognise each other's notified bodies. So CE marks that have been issued by a UK notified body may no longer be valid for the EU and the Northern Ireland marketplace. And similarly, UK CA marks can't be issued by EU 27 notified bodies. Now, in terms of the timelines, if you're impacted, then the UK CA mark isn't mandatory in GB until the 1st of January next year, so the 1st of January 2022. And then until the 1st of January 2023, for most goods at least, there's the option to affix the UK CA mark on a label onto the actual product. So that is, you know, another kind of easement that the UK government has brought in for the UK market. But from the 1st of January 2023, that UK CA mark must, in pretty much all cases, be affixed directly to the product. So really, if you're a UK trader that's impacted in this way, you should start building this into your design process ready for the 1st of January 2023. And then there's the notion of responsible person. So manufacturers of certain products like medical devices, for example, might require a responsible person to register and act on their behalf. And the thing is here, similar to notified bodies, the EU and the UK don't recognise each other's responsible persons. So if not based in that actual territory, you're going to have to appoint a local responsible person. So there's some real considerations there around that CE mark. Just touching on the e-commerce directives, that no longer applies in the EU, which is a real pain. So the EU, the e-commerce directive kind of allows EU online service providers to operate in any EU country while they're following the rules of the country in which they're established. And that's a very long-winded way of saying country of origin principle. So in the past, UK retailers, e-commerce retailers, could sell their goods anywhere across the remaining 27 member states and abide by the rules of the UK. But as I said, that framework no longer applies to UK providers because we've left the EU and the transition period's over. So the scope, within the scope of the directive, the kind of things that I'm talking about here are things like payment, indirect payment, that kind of thing that the directive would cover, and companies are now needing to familiarise themselves with the local jurisdiction in each individual member state where they operate. And the rules that govern what they can do are called the coordinated field, and they lay out the legal requirements in respect of online information, online advertising, online shopping, online contracting, and so on. And there may be a situation where online service providers now might need prior authorization. So they might need to be subject to prior authorization schemes such as licensing requirements to operate in a certain EU member state. Now, I've covered kind of like what the e-commerce directive covers, but what's out of scope is things like obviously it doesn't cover tax, it doesn't cover any gambling activities, anything about GDPR or e-privacy, or any legal requirements relating to the goods, such as, you know, safety standards and so on, labelling obligations and what have you, and any requirements relating to delivery or transporting of goods, which would be your Incoterms, and they're not covered by the EU e-commerce directive. But that's been a big loss to our e-commerce retailers. The audiovisual media services, so that works, that directive basically worked very similar to the e-commerce directive. So it had that country of origin principle where we just had to abide by rules of the UK and not by individual EU member states. Obviously, that directive no longer applies to services under UK jurisdiction that are broadcasting into the EU. But there is actually the European Convention on Transfrontier Television, or the ECTT framework. So there are some 20 EU countries that have signed up to that framework, and by doing so they're essentially allowing freedom of reception to services under UK jurisdiction. So where countries are party to that framework, then UK companies can operate under their Ofcom license. But for the countries that aren't signed up to that framework, then there may be an additional license in order to carry on providing those broadcasting services in those countries where they're not signed up to the ECTT. So companies really need to refer to regulators in relevant member states. You know, we're back to liaising with individual member states again to understand whether their Ofcom license is valid or whether there should be some other kind of license that's required. Just touching, now we're moving into the last 3 slides. This is time you'll never get back, folks, and I appreciate regulation is not a sexy subject, but it is having a big impact on how we trade with the EU. And I just wanted to highlight a couple of sectors, ones that we've been working with customers closely, and so we're kind of at the coalface of what the issues are. In terms of food and drink, there have been big changes regarding product labelling. So one of the biggest ones that's causing pain at the moment is this food business operator, or FBO as it's known. So some pre-packaged or pre-packed foods sold into the EU 27 now have to include the name an address of an EU or Northern Ireland FBO, food business operator, on the label. So an address in GB alone is no longer sufficient. So that's causing a pain, because it's kind of UK businesses thinking, well, who can I appoint as this FBO? Can it be an importer of my goods? Does it have to be another food processor? Who can I appoint? And that requirement for goods being placed on the EU Northern Ireland market is immediate. So that, you know, companies have had to do that from the 1st of January. Where goods are being placed on the GB market, obviously it's in the UK government's gift to have grace periods in that respect. So goods placed on the GB market can continue to use an EU, GB or Northern Ireland address until the 30th of September 2022. So it's really allowing companies to deplete their existing labelling stocks, which is welcomed. Equivalency on organic foods, this is great news. This was really good. So when you consider we sell some 255 million pounds worth of organic goods into the UK into the EU every year, that equivalency was really welcomed in the Trade and Cooperation Agreement. What it's basically saying is the EU recognises the 6 organic certification schemes that are operating in the UK, and that equivalence is in place until the 31st of December 2023. But equivalence can be revoked, so it will be reviewed in the lead up to the end of 2023, and you know, it's anybody's idea as to what happens. But it does, at least for the immediate future, it means that, you know, the UK's organic sector can continue accessing those vital EU and Northern Ireland markets, and it's brought a certain level of certainty to producers. Outside of the TCA, obviously, the Trade and Cooperation Agreement, Brexit's going to affect the export of organic products beyond the EU, because the UK's automatically dropped out of some of the equivalency agreements that were previously negotiated as part of those EU free trade agreements. That's something to bear in mind. Geographical indications I mentioned earlier, about those kind of food, drink and agricultural products that have that geographical connection, and how we're operating 2 schemes now. Country of origin, so food from GB can no longer be labelled as EU origin, although food from Northern Ireland can. You see where it gets complex. And food from GB can continue to be labelled as EU origin until September 2022. So again, we've got that grace period that helps with the depletion of existing labelling stocks. Health and identification marks, again, is causing a bit of pain. So for products of animal origin that are produced in Great Britain, so England, Scotland and Wales, the EC suffix that you'll see on those goods has to be removed, and the marks have to carry the full country name, United Kingdom, or an abbreviated code of GB or UK. Now those goods, those products of animal origin produced in Northern Ireland, they can continue to display the EC suffix, but they must carry the full name of United Kingdom in brackets Northern Ireland, or an abbreviated code of UK in brackets NI. So Northern Ireland is again in that kind of hybrid model there. EU emblem, which you'll be familiar of, so that's British foods or foods produced in Great Britain can no longer use the EU emblem. It may sound, you know, common sense, really, we're no longer part of the EU, but obviously it's impacting companies with their labelling and so on. It's causing a certain level of confusion. So they have to now use the British emblem to signify the country of origin on the food label when they're exporting to the EU. But again, British produced foods that are sold in Britain can still use the EU emblem until that 30th of September. So again, that grace period. The organic logo, because we've because the EU's recognised our UK control bodies, then we can continue to use the EU organic logo on GB organic food or feed until the 31st of December 2023. It's not compulsory though, and if it is used, it has to meet the EU organic labelling requirements and statement. There has to be that statement of agricultural origin on there as well. The biggest one that's impacting food and drink sector is sanitary and phytosanitary standards. So the fact that we're operating separate regimes here now. In essence, the UK government failed in its ambition of agreeing an equivalence mechanism for sanitary and phytosanitary measures. So the UK and the EU now maintain separate regimes regulating human, plant and animal health, and it is such a pain, and it's causing so much cost and so much distress to our exporters, not our importers as of yet, because obviously we have this phased implementation of import controls. So I suppose a little bit of light at the end of the tunnel. The Trade Cooperation Agreement places a duty on both sides to ensure that those measures, those sanitary and phytosanitary measures and border controls, are what they say proportionate to the risks identified, and they're going to be regularly reviewed by a new committee that's been set up, so the Trade Specialised Committee on Sanitary and Phytosanitary Measures, to see if they can make further facilitations moving forward without compromising that biosecurity. But I'm not holding my breath for it at the moment, and I think the problem is the EU isn't obviously feeling our pain at the moment because their exporters aren't having to jump through the hoops that our exporters are, and I think until that happens they may not recognise, you know, the full impact that these separate regimes are having on the food and drink sector. And of course now, because we have pushed back our import controls to the end of the year and actually March next year, then we've just delayed the problems. So I think, you know, both parties are less inclined to come back to the table anytime soon, but it's causing a lot of pain in this sector. Technology and innovation sector, I promise we're nearly there, guys. There's no mutual recognition on certified products, so that's when I'm talking about the CE mark, like I said before. So, you know, those electronics, machinery and consumer goods are going to need the UK CA mark from the 1st of January next year. GDPR we've covered, so GDPR is now incorporated into domestic law. So we've got UK GDPR. Please make sure it's referenced in your commercial terms and you're not still referencing EU GDPR. But remembering that that adequacy decision is yet to be ratified, but we're hopeful that that'll be done before the end of June. Digital trade, this is an interesting one because the EU had been reluctant to incorporate digital trade in the Trade and Cooperation Agreement. So the inclusion of an entire chapter dedicated to digital trade was a real departure for them. And the things that it kind of agreed was, you know, in relation to software and services, both parties agree not to impose any customs duties or tariffs on electronic transmissions, like software, for example, to adopt a broad definition of computer-related services, an agreement that you know, businesses don't need to obtain prior authorization for any services purely because they're provided by electronic means. Lots of things in there. So that was a big coup for the UK government in terms of the negotiation. And in relation to data localization, so both parties agree that they don't require that the use of computing facilities or processing of data takes place in their own territory, that there's you know, no requirement to make data transfers contingent on the use of computing facilities in their territory and so on. So that's a real big win there. In terms of telecoms and mobile roaming, really open approach to the telecoms market. Both the UK and the EU will continue to have access to and use each other's telecom networks. You know, they won't have to wait for prior authorization because before they can begin to deliver services. This is a really high level of access that goes way beyond what's traditionally included in a free trade agreement. In terms of cybersecurity, so the Trade and Cooperation Agreement has agreed a framework for cooperation in the field of cybersecurity, as well as the UK's participation in the activities of expert bodies like the EU Agency for Cybersecurity and the Network and Information System Cooperation Group. So there's a number of different groups that we're party to, and also there's this strong framework for cooperation around cybersecurity. In terms of providing services, so to be honest, the Trade and Cooperation Agreement provides coverage for services roughly equivalent to other EU free trade agreements like Canada and Japan. There's not a great deal better in ours, which is a real shame considering how tightly integrated we are and how close we are in terms of geography. Service suppliers, most service suppliers won't need a visa for short-term trips, and they won't face limitations such as economic needs tests. But again, the Trade and Cooperation Agreement has a huge chapter dedicated to all of those number of exemptions that apply to individual member states, depending on the duration of stay and the type of work that's going to be done. Financial services, really limited agreement on financial services in the Trade and Cooperation Agreement itself. Both parties have moved forward in their efforts to create a memorandum of understanding to establish a kind of equivalence framework for financial services, but it isn't going to be the same as financial passporting, which we had as part of the single market. So we will see, personally speaking, I hate to be so down about Brexit, but I think we will see some contraction in terms of our financial services sector, and we will see some EU cities benefit from the City of London losing revenue. In terms of European programmes, so we've now become an associate member of a number of EU programmes. So as I mentioned at the very beginning, Horizon Europe, Euratom, and a couple of others. So we're now paying to be party to those programmes, but we're an associate member, so we don't have as big a part in those programs, or perhaps the ability to drive those programs forward that we did have when we were part of the EU. So, you know, if you are party to those programs, or you're interested in those programs, then you'd need to seek UK government guidance to determine what the changes are and what impact they'd have on your organisation and ability to take part. And then the final slide is really the life sciences sector, because this is another one we've been exposed to a lot recently. The impacts of Brexit are substantial for the life sciences sector. You know, it affects so many of the benefits that we had as part of the EU system, like the centralised procedure for market authorisations, or what are called MAs, the EU portal for clinical trials, and the pharmacovigilance database. So, you know, so much of this has been withdrawn, and it's having a huge impact on some of these companies. So just talking about medicinal products, the kind of provisions that affect medicinal products included in the IP section of the TCA relate to the protection of commercially confidential information that needs to be submitted to obtain market authorization. So there's considerations there. In terms of research, the Trade and Cooperation Agreement, it kind of provides that as long as the UK continues to make financial contributions, the UK can continue participating in EU research programmes. So as I say, that's like Horizon Europe for the research and innovation funding programme. Crop protection products, so the UK now operates an independent pesticides regulatory regime. And the regulation of that falls under the Health and Safety Executive now. So that essentially means that new authorisations or amendments under both GB and EU pesticides regimes are now required to gain access to both to GB, Northern Ireland and EU. So it's that dual regulatory regime again. Legislation. As you know, when we're talking about life sciences, it's probably one of the most highly regulated and globally harmonised industry sectors, especially in the development of pharmaceutical products. And like many sectors, a large amount of UK regulation has originated from the EU and our participation in the EU. But now we're operating separate regulatory regimes. That means that the admin burden of those life sciences companies has increased significantly, and it'll just continue increasing because, you know, regulatory requirements, you know, change continuously. So they now need to be obtained under a new and different UK legal framework. So there's a lot of uncertainty and extra burden in this sector at the moment. In terms of clinical trials, so the UK has left the EU. Obviously, we're no longer able to take part in the European Regulatory Network for Clinical Trials, and regulatory responsibilities have now been transferred to MHRA. So for those of you who don't know, that's the UK's Medicines and Healthcare Products Regulatory Agency. And because recent government guidance doesn't address the status of existing approvals for clinical trials, or whether the UK will have to seek to align with EU clinical trials regulation, it's led to a lot of uncertainty within the sector. in terms of marketing authorizations, so the majority of market authorizations in Europe are applied for under the what we call the decentralized procedure or the national procedure, or they can also be applied for under the centralised procedure, which is EU-wide. Now, as the UK is no longer part of the EU, it's had to establish its own system for independent market authorisations approval through, again, the MHRA. So pharmaceutical companies whose presence and activities are exclusively in the UK won't be able to use the centralised procedure to seek market authorisations unless action's been taken to transfer key operations and activities to an EU member state, and they use an EU base for applications and compliance, which is just, we're seeing this a lot with regulation, the requirement to have that kind of EU presence, if you like. RD, research and development funding. So the EU's provided funding and coordinates research collaborations through funding programmes, like I say, through the Innovative Medicines Initiative and Horizon 2020. And to be honest, UK-based researchers were amongst some of the largest beneficiaries of those programmes, and obviously, you know, that's no longer the case. Pharmacovigilance, so this is really around implications over which regulatory body and system is going to be used. So EU pharmacovigilance, that system's coordinated by the EMA. Whereas in the UK, the MHRA is now responsible for that. So we're operating two different systems to submit individual case safety reports and, you know, depending on which market the product's being placed. So again, it's just that dual system that is so painful. And again, finally, you know, regulatory authorities, the MHRA based in the UK, their workload has increased significantly because they're taking on regulatory work that would have previously been handled at the European level by the EMA. So where previously the EMA cooperated with, say, the International Council of Harmonisation, ICH, or the FDA, the US Food and Drug Administration, and several different others, you know, other competent authorities, the MHRA now has to negotiate its own cooperation agreements to replace those that were agreed by the EMA at the EU level. So just a huge amount more work, a lot more cost and a lot more work, essentially. That is what I've got for today. As I say, I do apologise because it is not, regulation is not a sexy subject at all. I'm just looking to see if we've got any questions for today. I can't see any at the moment. But again, you've got my contact details there. If there is anything that I've said today that has an impact on you and your organisation, then, you know, by all means, drop me a line and I'll quite happily come back to you. My service level agreement is not what it was because it's so crazy at the moment, but I will get back to you in time. And again, yes, just keep an eye out. Your federations and associations are fantastic sources of support around regulation impacting your sector. In terms of these slides and so on, they will be, the recording will be uploaded to YouTube at some point, probably in the next week or so, and the slides will be distributed as well as a link to the recording via Eventbrite, so you have it to refer back to. But if there's no questions, I'd just like to say, oh, hold on one second, I have somebody in the chat saying something. Will the recording? Ah, yes, absolutely. So Jennifer, yes, absolutely. As I just said, it will be sent out via Eventbrite. Just bear with me, it'll probably be a week or two, but it will be sent out to you, and please feel free to circulate. That's absolutely fine. But thank you very much, everybody, and enjoy the rest of your Tuesday, I think it is. Yeah, Tuesday. Thanks very much, everyone. Take care. Bye-bye.